Well, government has chosen to ignore the Helen Suzman Foundation's call to explain why exactly Jacob Zuma was released on medical parole. Minister Ronald Lamola and Correctional Services Commissioner Arthur Fraser had until 5 o'clock yesterday to provide the names of the decision makers and detailed supporting documents. Now that they failed to do so, the foundation says it'll exercise its rights. Well, let's find out what this means from Christopher Fisher, who's a legal researcher with the Helen Suzman Foundation. Christopher, thank you so much for your time. Arthur Fraser has admitted that the Medical Parole Advisory Board did not recommend medical parole for Jacob Zuma, but he decided to overrule it. Have you had any access to those documents? And if not, how does one access those justifications?
No, we haven't had access to the documents, despite requesting them via correspondence with the Commissioner and the Minister. So really now we must assume that those documents aren't going to be forthcoming absent some sort of direction from a court. So that's what we've done now. We have applied to the High Court to seek in the first instance an order compelling the Commissioner to release his decision, the reasons and the documents that have supported that decision and his set of reasoning, so that we can better determine and move forward with a review of the lawfulness of the Commissioner's decision.
I mean, Arthur Fraser said that he was quite sure that the documents would be accessible to Parliament. On what grounds do you ask the court for access to that documentation outlining the justification of him overruling the parole board?
So we view our legal standing in this matter as essentially being supported by two sets of reasons. The first is that we would bring a review of the Commissioner's decision in the public interest. So in the interest that we all have in determining whether or not Mr. Zuma's medical parole was issued lawfully, or whether or not there was some attempt to undermine the rule of law expressed in the Constitutional Court's order. But secondly, we bring the application in our own interest, because the Helen Suzman Foundation was involved in the series of cases that led up to the Constitutional Court's order that imprisoned Mr. Zuma in the first place. So if there is a risk that Mr. Fraser's decision has undermined that court order, we believe that our rights as a litigant in those prior matters are implicated in this current one, and that entitles us to the record of the decision, and it entitles us to an opportunity to review the decision on the basis of that record.
I mean, Arthur Fraser did overrule the parole board, who said that Jacob Zuma's condition was stable. He has the right to do that, doesn't he, considering his position?
We contest that in our court application. So the decision to place an offender on medical parole is a power that rests with the Commissioner indeed, but it is not simply with the Commissioner. The Medical Parole Advisory Board plays a crucial role in determining the medical aspect of that decision. The Commissioner is not a medical expert, and to the extent that a decision to place someone on medical parole is a medical decision, the role of that expert panel should be fundamental to the decision being made. So it's not clear that the Commissioner has the power to simply override the Medical Parole Board. And even if he can find a power somewhere in the legislation to do so, the overriding power, the override cannot be without good reason. There cannot be an irrational or unreasonable basis for that override. So on either of those lines of legal argument, the review is still a ripe one to bring, and it makes it all the more important for us to see that record and to see what went into the Commissioner's decision.
Lastly, Christopher, and it's pure speculation, but it is out there that Arthur Fraser, being the former SSA head, was close to Jacob Zuma, and it was a done deal all along that he would be granted medical parole. Has your research or information managed to unearth any kind of information that would suggest that this was true, or is it purely speculative in your view?
Well, I think we have to let that remain as speculation at this point. An overriding theme of our application is that we have been left in the dark about the rationale behind the decision. So until we have that set of reasons in front of us, I think we can be we should leave those sorts of issues as speculation. But there's certainly the application itself does give grounds, does express some suspicion around the process. So let's hope that the application brings to light what we all need to know about the process.
Do you have a date yet, or a timetable for when the case will be heard, or when papers need to be filed?
Not yet. That's part of our initial application, is to ask the court not only to give us the record, but also to set a timetable for filing of papers for the review. So the timetable is part of the application, and it will be in the court's hands.
All right. Thank you so much. That was Christopher Fisher of the Helen Suzman Foundation.